Welcome to Pushing the Envelope, the podcast where we sit down with people shaping construction, development, and infrastructure across Canada. I'm your host, Tanya Scapura with Bothwell Accurate, and today we're going to be taking on some of the biggest issues impacting builders right now: tariffs, payment rules, compliance, and dispute resolution. These topics may sound technical, but they directly affect project costs, timelines, and risks. Every developer, general contractor, and subcontractor is feeling them right now. Joining me today is Neil Khatri. He's our in-house legal expert at Bothwell. He's going to break down what these changes really mean for projects on the ground and how smart players can really protect themselves and keep these jobs moving ahead. Hi, Neil. Thanks for joining us.
Thank you for inviting me.
No worries. So I'm going to start with asking you a couple questions. You've been at Bothwell now for how long?
5 years.
5 years.
Just finished 5 years, yeah.
Okay. Did you want to give a little background on yourself, introduction?
I joined Bothwell back in 2020 at the beginning of COVID when things started becoming very litigious and a changing atmosphere for how construction operates. And since then, I've developed the in-house legal team for Bothwell in order to maneuver through the various legal issues that come up throughout this period of time.
Okay, great. So we'll dive right in and start asking you some questions. So starting on what everyone's talking about right now, of course, tariffs on specifically in our industry, steel and aluminum. We keep hearing about these new tariffs. And for a developer or general contractor sitting at the table or looking to start a project, what do you think these tariffs mean for them with regards to budgets and timeline?
The way that the tariffs work are they're basically a new border that imposes strict costs towards what you're going to bring into the country. Two big things are happening. First, Canada added a 25% surtax of steel if it's created or melted in China. And then the same thing for aluminum if it was smelted or casted in China as well. Basically, even if the final product was created in USA, if the manufacturing product was created in China, that adds automatically a 25% tariff into Canada itself. Now, with respect to USA, this is how it impacts the glazing team. So a curtain wall unit built in US can get surtax if the aluminum came from China. Second, some steel products now sit under a tariff rate quotas. This means that you can only bring in a limited amount of steel from outside of Canada into Canada. Otherwise, they will charge an additional 50% surtax.
Oh, wow, that's quite a bit when project budgets are already high.
Yeah, exactly. So now a lot of GCs are contemplating buying directly from some US suppliers, otherwise Korea, Mexico, EU.
Okay.
Despite this, they also have to check where the product originated from. So regardless, basically the subcontractor needs to ensure that their supplier's due diligence contemplates where the product originated from.
Okay, that makes more sense. So sort of understanding where they're going to source or spec the product from before they even get involved in the budgeting stage. So
Exactly.
first thing is maybe working with the architects and things like that to ensure they're specing products from maybe the EU or other areas. And I know at Bothwell, we've been doing our due diligence with our suppliers and outsourcing different ones and traveling globally to make sure we're finding ways to avoid these so we're not kind of stuck. And since COVID, I think you saw these things starting to happen too, because borders really tightened up around then.
Yeah.
So I know we were getting ahead of things at that time also, which was helpful now.
Exactly.
So do you think we're really seeing these tariffs bite into glazing and metal packages already, or is it more about just planning ahead at this point? Have the effects started or?
The effects have started, especially with respect to suppliers. They've had to now go to outside manufacturers, outside of US, outside of China. Recently, one of our suppliers had to go to Korea to try and contemplate how to bring in aluminum from there. And although it may be more expensive, it is still cheaper than whatever the cost would be in comparison to the tariffs added to it.
Okay, great. Okay, so moving on, let's get into a little bit more about the prompt payment or lack thereof in BC.
Yeah.
You had mentioned that there are some changes going on. There are some changes that need to happen there because that doesn't exist, correct? Do you want to tell us a little bit about the prompt payment and what it means to start, or what exactly it is?
It's to streamline the payment processing for contractors, owners, GCs in such a way that the bottom supplier or the bottom service subcontractor is not left without payments for their own people and labor. In Ontario, they have a 28-day rule. So the owner has 28 days to provide payment to the GC. And thereafter, the GC has 7 days to provide payment to the subcontractor, and then it just flows down through there. Recently, Canada created their own prompt payment for any federal projects, and then other provinces followed suit. Unfortunately, the only province that has not yet followed suit is BC. And this is the province where we see a lot more disputes and more arbitration and concerns over the project. Because at the end of the day, I've seen various projects where the owner just decided not to pay and they end up in court cases. And that is a very lengthy and costly process.
Okay, and Bothwell, obviously doing work in Ontario and British Columbia, I'm sure you deal with this quite a bit. So you're seeing a big gap in the difference between BC and Ontario in
Yes.
payment terms and just length of actually receiving payment.
Exactly.
And it trickles down, right? So as the subcontractor, we probably see it last.
Yeah.
In practical terms, what do you think that means for like GCs, subs, and developers working out west? Should they be trying to set their own terms, or would that not even make a difference right now? Would it need to be?
There may be some instances where the owner decides to just abide by the current legislation, which doesn't enact the prompt payment regime
In BC.
in
right?
BC,
Yeah.
right? In most cases, a situation where the owner refuses to pay for no reason whatsoever. It's related to do with potential like deficiencies that are not done properly. So at least that allows some control of the quality of work that's being done. But then that leaves the person at the bottom with no money.
Yes, yes. And I think all the different trades need to be at completion before even another one. So if something in security or lighting is lagging, then the roofer still needs to wait, even though it may have been done beforehand.
Exactly.
Correct? So upon full project completion. So if you are a developer, or contractor, or subcontractor doing projects across multiple provinces in Canada, what do you suggest? Do you suggest just having like a regime across the country internally and then just hoping that that will help with the legislation, or?
Well, right now it's what works for most GCs, where they just standardize their contracts throughout, obviously in line with whatever legislation is in those provinces. But at least with proper paperwork and a proper contract, you can streamline the project a lot better.
Okay, so it does help to have that.
Yeah.
And when do you see this legislation possibly coming into place? Like, are they talking about implementing it soon? Is it a conversation that's being had out there?
So there has been talks about it for this year, but then there's no guarantee that the legislation is going to enact it or go ahead with the new legislation anytime soon.
And they're the only province in Canada that doesn't have it.
The only major province.
Okay.
Yeah.
Okay. Interesting. So I guess for now, keep standardizing our own terms internally and then hope that is there anything else we can do as an industry to sort of push for it to implement?
There's always some form or measure of trying to, I guess, in a way, say lobby, such that the government should understand that if they want to build quicker, if they want to streamline projects in BC and avoid long drawn out processes, they need to at least have some measures in place, so that way it's less dispute between owner and GC or GC versus sub, and more so here's the process for everyone to follow. If you have any issues, you can follow this process and deal with it that way. Now, even if there's a prompt payment, that doesn't mean that you have to automatically pay. There are some things such as a notice of non-payment. So if there are any issues throughout the project, you issue that notice saying, hey, unless you fix this, we're not going to pay you. And so as long as they have these good measures in place, then that could at least help build faster in Vancouver or throughout BC.
Okay, great. And you find it is actually slowing down builds or contracts right now, not having that legislation?
In a way, I believe it is, because at the end, if there are any disputes, then that just kind of strongholds the entire project.
So let's move on to supply chain compliance. The new Act S211, is that what it was? Do you want to tell us a little bit about the Act? I know it's about supply chain transparency, and it requires annual reporting on forced labor, correct?
Yeah.
Do you want to talk about a little what that means for construction firms in terms of practicality, what we need to do with this now being implemented?
Basically, what this new legislation is all about is to showcase that we have an ethically sourced product being used on our projects. The ownership, through flow down measure, needs to ensure that it's GC. its subcontractors, its suppliers, its manufacturers, all the way to where they're sourcing the material and where they're mining, etc., are doing so in an ethical way.
Okay, that makes sense. So, how are contractors and suppliers expected to prove this compliance? And what happens if someone doesn't?
The only way to prove that this is being done is creating a supply chain map. And so what you would have to do, and what this mostly entails, there are some areas, for example, in China, that do use forced labor or child labor. And what some companies have done is that they've used or created a outline or a map using those companies as the starting chain, and they've mapped towards what manufacturer uses them, or what supplier has used them. And so using these specific companies that have outlined these maps, you have to then see whether or not any of your suppliers fall in that chain. If they do, then you're at risk of having penalties. They can be as much as $250,000 for each infraction.
Okay, so right now, as subcontractors, we're really relying on our suppliers to make sure they're doing their due diligence before we go ahead with any contracts or specific products.
Yeah, there are some codes of conduct in place. So in simple terms, the suppliers should now be more weary of what and where they're buying from. Otherwise, Canada will impose severe penalties on them.
Okay, and are there things we should be changing in our contracts, or do you recommend that it's starting from like the owner developer standpoint, trickling down from their contracts, and then?
So the same way the owner's contract trickles down to the GC, right? Our obligation is to trickle those same obligations towards the suppliers as well. And so I would suggest creating a standard code of conduct that every supplier should sign off with, to ensure that at least you are contemplating your due diligence, to ensure that whatever you are sourcing through your supplier is ethically produced.
And how are they finding that? Are they like doing audits now on jobs to make sure that it's happening? Or when would the audit start? Would it start before we order the product, or when the job's in progress? And how do they enforce it? That's the word.
The confusing part of the legislation is that this is more of a voluntary audit mechanism, whereas most companies, or all companies that meet a certain threshold, need to complete their own audit and provide this information to the government so that they can review whether or not whatever you're providing is ethically sourced. Now, this isn't to say that if you have no measures in place, that you have done nothing with respect to the current ongoing legal change, that you'll be in trouble. This is to ensure that if you, let's say you have not done anything till date to impact this area, that you should start making or putting measures in place to ensure that you're ethically sourced.
Okay, that makes sense.
Yeah.
Okay, so we'll move on to the adjudication lessons from Ontario.
Yeah.
Ontario's adjudication process was meant to keep jobs moving by resolving disputes quickly. Do you find this is actually working in practice?
I'm going to say yes and no. The reason why I can say yes is because it is a very streamlined and quick process, at most 30 days, where if there's any issues with change orders, if there's any issues with payment or extras or any other aspect related to the contract or construction that falls within this realm of adjudication, it's an easy way for the parties to mediate the issue, right?
Okay.
However, the reason why I also say no is that even if the decision is made by the third party, there's no enforcement mechanism for it. So they don't have to abide by the decision made.
Okay. So what lessons have we learned so far, and how can the contractors, subs, developers, how can we make sure that we're adjudication ready before even like those disputes arise?
So the biggest thing for this is paperwork. So as long as you're documenting whatever issues that transpire, for example, if there's a delay on the project, you need to ensure that from day one, not only are you making a record of it, but you're also notifying the contractor or GC or the owner that, listen, this is an issue that we're facing on this project. Here's our record of it. And so at least the project keeps going.
Yes.
And even if you're not able to come to a decision that day and then through the adjudication process. Now, this is something that most people don't know came from UK in and of itself. They started the process of adjudication which has worked really well there. And so Ontario decided to bring the same process in here. It's taken a few years for it to build up, but at least this is allowing Ontario to now streamline more projects and let it go at whatever pace it needs to go to or through, instead of going through court or arbitration procedures. This is something that GCs and owners can deal with during the time of the project in and of itself.
Excellent. That makes sense. And you see this eventually then going into BC as well. And do we have a blanket contract across both right now, just sort of to protect ourselves, or does it have to be done through like the provincial legislation?
So in BC, that is all done through arbitration or courts. There's no adjudication process yet, because the only reason why it works in Ontario is because they created their own organization that deals with the adjudication in Ontario. They don't have those regimes in BC, so you won't be able to deal with it in the same way you deal with it here.
Okay, that makes sense. So essentially, if you zoom out on the conversation we just had, we talk about tariffs, payment rules, compliance, adjudication. What's the common thread here? What do you think every general contractor and subcontractor should be doing today to sort of protect themselves? Just really tighten up their legal department, make sure they're doing their due diligence before any contract starts.
Good paperwork always wins. And so whether it's with respect to the contract or the scope or the spec, the details, anything that you do in the project needs to be noted. So in essence, good paperwork always wins. For example, for tariffs, if you have the original permit or of the origin of the product prior to bidding, this will help you avoid the border issues. For payment concerns outside of Ontario, if you have clear invoice rules, if you have a fast dispute resolution system, or if you have provisions that entail how payment is processed, that'll help ensure that that process is streamlined. Same thing for with respect to the supply chain. If you're filing your auditing files online, if you're ensuring that your supply mapping is done prior to you dealing with various suppliers, that at least helps ensure that you're ethically sourced. And the same thing applies for adjudication as well.
Okay, that makes sense. And that sort of ties into our final question. What's the one thing you wish people understood about contracts that could save them a lot of time, money, stress?
So the one thing to understand about contracts is it's not there to redline or create more issues or more borders for you to be able to deal with the project in and of itself. It's to ensure that you have proper mechanism in place, so that way you can complete the project while avoiding further disputes.
Makes total sense. So just basically, like you said, you can't have too much paperwork in these types of contracts. Everyone should be engaging their legal department or outsourcing it, at least if they don't have it, as much as possible and as early as possible.
Yeah.
And just make sure we have all of the right certifications in place and we're in compliance with our suppliers, subcontractors, and so on and so forth to make projects run smoothly.
Exactly.
Sounds easy. Okay, well, Neil, thank you so much for joining us today. It was great having you. Your knowledge is so important to us, and we're really thankful to have you here at Bothwell.
Thank you.
Thanks for joining the podcast.